appeal in the matter of M.A. Child.
Yes, my lords, good morning. I stand slightly out of place as the appellant. I do so at the request of my learned friend Miss Mayor, King's Counsel, given her hearing difficulties. If I sit or if I stand to her left, she won't be able to hear me. And subject to my lord's agreement, she's sit there. I appear on behalf of the appellant. I'm with Miss Taylor, my junior, who sits behind, and our instructing solicitor. The mother isn't present in court. The court agreed that she could attend remotely and she will be watching matters on the live stream.
Yep.
My learned friend, Miss Mayor, King's Counsel, leads Mr. Seal on behalf of the respondent local authority. And in court, they're accompanied by the newly allocated social worker and team manager. My learned friend, Mr. Goodwin, King's Counsel, leads Mr. Cooper Hall on behalf of the child. And present in court is the child's guardian. My lord, we'll have the detail of the appellant's case set out in the skeleton argument. And
indeed, and we have read, of course, all the skeleton arguments as well as the judgment below.
I'm grateful, my lord. At the bar, the agreement was that I would make submissions on behalf of the mother first. That would be followed by the local authority and with the guardian to finish. Subject to my lord's better view.
Well, I'm not going to disturb with that arrangement, but it seems a slightly odd way of proceeding, given that the guardian is supporting the appeal.
Well,
one would normally expect all those advocates supporting the appeal to go first before the respondent is required to respond. But if that's what's been agreed, I won't disturb.
Well, I'm grateful. My lord, the appeal brought on behalf of the mother against the court's order, in essence, addresses whether it's appropriate in all the circumstances, or it was appropriate in all the circumstances, to remove a young child from the care of her mother, the only carer she has known since birth, at the conclusion of almost 15 months of scrutiny by the local authority and the court process. And on behalf of the mother, what we say is that the judge failed properly to take into account what that period of 15 months demonstrated. And what that demonstrated was the mother's clear ability not only to provide good enough care for the child, but to protect that child from what was the known risk posed by the father. And we say that the court failed properly to assess the real significance of what was the child's reality in that period of time. From the point of the mother being served with the expert report, as my lords will have seen during her labour, what we say is that the mother acted throughout to protect that child, and she succeeded in so doing. And she succeeded in doing that in the face of the local authorities' concerns about her ability to do that. The experts' assessment that from a psychological point of view, she didn't have the capability to do that. She did that with the benefit of protective measures. As the court will have seen, there was an interim care order throughout, an exclusion order in place.
We're not sure that we've got all the orders that were made. We may have the interim care order, but there was an injunction as well, I believe. Do we have a copy of that as well?
We may not have the actual copy of the exclusion order that prevented the father. We can access that from the original bundles, which we have digitally,
right,
and we can circulate and provide that.
I think that would be helpful, please.
My own junior, Mr. Taylor, will do that presently. Those protective measures also included the working agreement, and my lord, that is also, I don't think, included within the supplemental or core bundle. It's in the care proceedings bundle. It's a short document. It's child specific and child centred, and we can circulate that as well, so the court has the full panoply of those protective measures. And under that interim order, the local authority conducted social work visits with the mother approximately every 4 to 6 weeks. And we say that's not an unusual framework. It's a framework that the local authority clearly thought throughout would be sufficient to flag up any issues of immediate risk of harm to the child. The local authority did not seek at any stage to remove the child, and never did it assess any imminent risk of harm, as it would no doubt have been conscious of the need to watch for, and it did not do that. And we say that's of real relevance, not only to demonstrate how mother met the challenge of protecting the child, but also how the local authority considered it appropriate to check whether the mother met that challenge. And taking matters forward into the future, as the judge clearly had to in considering welfare, we say those elements are of real significance, because those are precisely the sort of protective measures that could have been in place going forward. Courts are often told that the best indicator of future performance is past performance. And in this case, on behalf of the mother, what was submitted at the time, and we reiterate now, is that this mother demonstrated all that was necessary to keep this child safe. It was agreed throughout, and it's addressed in the judgment, it's agreed by social workers at various points in the proceedings, that the mother was providing good enough care. The child's presentation, both at home, contact sessions at meetings, was always immaculate. The home environment was the same. And that, we say, is of real significance, because this is not a mother the court found was readily able to accept the risk, readily able necessarily, according to the expert, to formulate an understanding of risk. Troubled as the mother is, according to the expert, with issues of bereavement and trauma. And we say that that assessment of the mother actually makes her performance in those 15 months all the more remarkable. The authorities draw a line between children at home under final supervision orders and children at home under final care orders, indicating that for there to be a final care order, the case needs to be exceptional. Well, what we say is that this case, in essence, isn't actually exceptional. What's exceptional is the fact that the mother has been able to do what she has done, given everything that she's experienced, and given what has to be accepted is her reticence to accept and perhaps understand at all stages the risk posed by the father. It's right, and the judge recognising it, that in evidence the mother comes perhaps belatedly to an open expression of the risk the father poses. But throughout, there was never at any point until the incident of the 10th of September, which I'll come to in a moment, a suggestion that the working agreement, which was not to bring the child into contact with the father, allow him to care, or allow any contact between the mother and the father with the child present, never a suggestion that that working agreement was breached once in that period of time. no suggestion that despite all the concerns raised about mother's attitude to risk, the concerns raised about how mother's supervision protection plan might work if father was in the home, no suggestion throughout all of that that this child was actually put at risk. And we don't resile from the issue of risk in the sense that the father, given his convictions, clearly poses a risk to children. It's of relevance that the judge made no finding, and my Lords, of course, has the helpful schedule of findings at the end of the judgment, made no finding that the mother had harmed. And my Lords note that's at E80 of the core bundle. I think that will be PDF 81. No finding that the mother had caused harm to the child.
Can I just ask you about when you're dealing with risk, the risk the father posed? Because there was some expert evidence to suggest that he wouldn't pose a risk to a child for another 5 years.
And that's one of the elements that we say that the judge failed properly to factor in.
Is it in the judgment at all, that finding? I mean, I know it's referred to elsewhere. I couldn't find it, but that may be my misreading of the judgment.
My Lord, I think there is reference to the nature of the risk posed as identified by the experts.
Lord, is at the bottom of E29 of the core bundle,
Thank you very much.
paragraph 195 of the judgment.
So, my Lord, that element of risk, it's relevant, of course, and it cuts both ways. Because if the father isn't actually posing a risk at this point in time, it may be said, well, then mother's ability to protect from that risk doesn't have the same weight as if she'd been protecting that child throughout a period when the father was, as the expert identified it, actively posing a risk. But of course, it's of relevance that the risk the father may pose to this child is, to use the turn of phrase in the authorities, it's a slow burn. This is, if the expert is right, a risk that is not going to materialise for some considerable period of time. Of course, it's highlighted on behalf of the children's guardian that has relevance to how does the court address at this stage the proportionality of a removal if the risk such as it has been identified posed by the father isn't actually going to materialise for another 5 years. And I think the relevance at that point, of course, is that that not only provides the mother and child with an additional opportunity to show how she can protect and be protected, how the mother can work with the local authority, how with the local authority's support, subject to the mother's own views about accessing therapeutic input, as she indicated to the court, well, she would address it with the GP if she felt she needed it. But there is a considerable period of time before that risk might materialise. And to act now to avoid a risk that, if it materialises, would materialise much further down the road, we'd say would be disproportionate, certainly premature. And of course, one of the matters that the judge highlighted, and it's picked up by my learned friend Mr. Goodwin, King's Counsel on behalf of the child, is that the judge took the formulation of protection for this child as the fact that the child would be much better off, safer, with the grandparents. We make the point in the written document that, well, when it comes to comparison, first of all, the fact that she may be safer with somebody else doesn't mean to say she's going to be unsafe with the mother. So we would say that's a misstep in any event. but the paternal grandparents are untested. They don't have the benefits of 15 months of proper safeguarding.
Can you shed any light on 2 points of fact that are of interest to me? First of all, there is a suggestion that an application was made, or some suggestion was made to the judge at the outset of the case, that the paternal grandparents should give some evidence to the court. Can you just develop that a little?
As I understand matters, and I'll be corrected, there was that suggestion made, but I think the judge's view was that she had the parenting assessment, or the connected persons assessment of the paternal grandparents, and that's the evidence that she decided to rely upon. She had the family group conference, which highlighted some concerns about the paternal grandparents' attitude to risk and the father. She had, of course, the expert's view of the grandparents, which the judge rightly put to one side because, of course, the expert hadn't assessed the grandparents. So I think that was the basis, and I'll be corrected if I'm wrong. I'm not going to be corrected. That was the basis why the judge.
So the judge decided to place the child in the care of grandparents who the judge had never seen and never heard any evidence from.
My lord, yes, in a nutshell.
And is it right that the father was still living with the grandparents at the time?
Yes. And this was another issue about, there was discussion of a transition plan and how that could happen, because of course that issue had to be addressed as well.
My lord had in fact anticipated my second question. Can you just then clarify one point within that? The father and the mother had been living together up to the point of M's birth, correct?
Yes.
But as soon as M was born, they separated, physically separated. Yes. And so it was from August of 2023 that the father had then been living full-time with the paternal grandparents.
I'm going to check that it was full-time, but that's certainly my understanding. That's the point in time when there's the physical separation. Yes. I think that's accepted by all.
So he has been there now for 18 months or so.
Yes, we do. We think that is right. There was certainly no, I think, scrutiny or inquiry as to whether he'd been there the entire time, but that was certainly the position at the hearing. He'd been in the family home is referenced in the family group conference. And it's a little confusing, but I think the family home is there referenced as the paternal grandparents, because there's discussion about how they would understand the need to make sure that any caring of the child had to be done absent the father.
Yes. And a concern on the paternal grandmother's part, I think, of rendering him homeless.
Yes. And that dynamic isn't addressed. So not only does the judge engage with the local authority plan for placement with the grandparents, absent any direct assessment of their evidence, she does it in the absence of it being tried and tested, and she does it in the knowledge that the family group conference highlighted the grandparents' own concerns as to whether and what risk was. They're applauded for raising, oh, well, what risk does he pose, and is that right, and why haven't we been told? They're applauded for raising those issues, whereas the mother, of course, when she raises those issues, is identified as being overly defensive or confrontational, which we say is an unfair assessment. It would be one thing if the judge had had the benefit of the grandparents in evidence, those issues being put to her, and she would have been able to make an assessment at that point. It still wouldn't have offset the fact that they hadn't cared for the child in the way the mother had.
Has Em ever been to their home?
I don't think Emma's ever been to the home, but she's certainly got a relationship with the grandparents they've cared for.
Yes.
I mean, this was one of the issues about how a transitional plan was going to be affected on the basis of the plan. I think it was resolved that it may take over 3 days on the local authority's case to do that.
Could you just check, and maybe that Ms. Mayor is able to do so, whether she's ever been to the paternal grandparents' home?
We don't think there was any opportunity for the child to go to the paternal grandparents, of course, because the father was living there.
I'm sorry, just one supplemental question. To the best of my reading of the case, the only time in which the paternal grandparents had ever, as it were, provided unfiltered their view about the case was when they emailed the Guardian on the 4th of November. And that provoked then a conversation between the social worker and the paternal grandparents, which is then reproduced in a witness statement. I'm right in understanding that all of that material was then before the judge, before she formally handed down her judgment.
Yes. Yeah, my lord, it was. It was alongside the evidence about the incident of the 10th of September. That was the evidence that came after the start but before the end. My lords of
And there's no, as it were, addendum to the judgment dealing with that.
no, the judgment deals specifically with the evidence relating to the 10th of September because of
Yes,
course
but not what my lord is referring to, namely the paternal grandparents' reaction to the decision.
well, I'll be corrected, but I don't think there is any specific reference to how that was received, how that evidence was then considered, and what impact it had on the judge's assessment of that being a safer placement. And the real in-depth comments by the judge in relation to the grandparents are really when she sets aside the experts' concerns about the grandparents, because she says, well, that's the expert overstepping her mark. She relies on the connected persons assessment, which of course was prepared, I think, in February of last year, and of course then doesn't engage with those issues that were clearly raised by the paternal grandparents. And we say that's an element of unfairness, because that was all, in a sense, ignored or explained away, whereas when it comes to the mother, despite what she's been able to do, the judge is very ready to accept the experts' views about the mother's psychological profile and characteristics, accept what the social workers say when it comes to welfare planning, namely, well, whatever you can think of in terms of a protective measure won't work, but doesn't properly engage, if at all, with, well, if that's true, how are those protective measures going to work with the grandparents? At that stage, it wasn't even clear that with the child living with them, how was it that they were going to deal with the family dynamic of having to ask their son to leave? Because clearly that would have to happen if it was ever going to be remotely realistic. So we say that the approach of the court in that respect highlights how the negatives against the mother were focused upon and were not properly balanced with what evidence there was as to the positives that she brought. The mother is dismissed, we say, out of hand and unfairly, because of an assessment as to what she might be able to do in the future without proper regard to what she's done in the past. The grandparents are lauded for what they will be able to do in the future without any understanding of how they could do that and how they would do that. And drawing a distinction in terms of protective measures between the grandparents and the mother, we say is flawed, because it's the same set of protections. One can imagine there would have had to be an exclusion order preventing the father, a working agreement to ensure that the father wasn't at the home, wasn't in contact with the child unsupervised. That simply hadn't at that stage been tested out with the grandparents. And so we say that's another an unfairness, because there is an absence of proper judicial assessment and judicial balancing. And in such a case, for the judge to assume those matters about the grandparents, particularly in light of how those matters developed during the course of the final hearing, without hearing from them and without properly understanding the impact of their views, did the child a disservice. She makes assumptions about the grandparents. She didn't need to make assumptions about the mother because she had the evidence of what the mother had been able to do. And so, my lords, what we say is that the judge was wrong to accept, in essence, what the local authority was saying, which was this child cannot be safe with the mother in circumstances where the child had in fact been safe with the mother. What is it that was going to be different? Well, what we say is nothing was going to change. The mother knew throughout that a misstep, a proper misstep, by which I mean one that placed the child at risk, would only have one consequence, would have been removal. What comes to pass in respect of the 10th of September? We say this is illustrative of the approach of the court and indeed the local authority. When the local authority think there is evidence that the mother and father, or rather the mother, has brought the child into contact with the father, they act very quickly indeed. Evidence is filed. It goes back before the judge, and there is evidence from social worker and the mother. The judge indicated that she was going to hear evidence from social worker, mother and father, but in fact the father prepares a written statement and doesn't give any evidence, so he's cross-examined on the point. The local authority recognised, rightly and fairly, that despite their initial concern about that incident, there is no evidence that in fact mother met with the father or brought the child into contact with the father. And they, at that point, decide not to seek any findings on the point. That doesn't satisfy the judge. She indicates in her judgment that what was of concern to her was whether or not the parents had been open and honest. Had they cooperated? And that's why the social worker is cross-examined, that's why the mother is cross-examined on that point. And my lords will have within the...
So what is the judge postulating that the mother has not been open about?
Well, my lord, that's the real difficulty we have with this part of the judgment, because she says in her judgment... The Honour deals, the judge deals with, the judge deals with this, it's at E65, it's paragraphs 435 to 442 of her judgment. And it's at paragraph 439, where she says, within the context of this case, where I'm being asked to sanction the child remaining with the mother in circumstances where there are concerns about the ongoing nature of the parents' relationship, one identified risk factor is the mother's ability to understand the risk and to work openly and honestly with professionals. This, in my judgment, was an important and relevant consideration. I heard limited evidence on this issue from the mother and from the social worker. So it was clear from that, and the context being that the local authority did not seek findings because they accepted that the mother hadn't brought the child into contact with the father. The judge clearly wants to understand whether this is an example of the mother's failure to understand risk or to work openly and honestly with professionals. Now, unfortunately, the judge then references in the following paragraph, I do not consider it necessary to reiterate that evidence here, as I make very limited findings in respect of it, and do not consider they've had any bearing upon my overall decision. And then a little further over the page, paragraphs 441 and 442, she continues in respect of what can only seems to be a potential finding that she seems to make at 441. The only other observation I make is that the mother did not mention that she had left the child in the care of the paternal grandmother when asked about her movements. That simply reinforces the level of suspicion between mother and the local authority, and that when allegations are made, it requires a forensic investigation to establish the truth, which would simply not be an appropriate safeguarding tool. And then concludes, I do not consider that my limited findings in relation to the conversation between the social worker and the mother have any bearing on the findings I've made. When one looks at the schedule at the end of the judgment, those paragraphs where she breaks down the summary of findings, there's no specific reference we can find to that conversation or to the incident on the 10th of September. She clearly considers, first of all, whether mother had brought the child into contact with the father as being relevant, and one would accept that that clearly is. That's not the case. She didn't. It's accepted by the local authority. There's no finding to that effect. She then goes into the issue of openness, and that, we say, again, is one of the issues that the judge has made a false step on, and that's overplaying the issue of dishonesty in this case. Because she's looking there, we say, for a smoking gun. She's looking there for an incident where the mother had an opportunity to be protective and wasn't. That she put the child at risk, but we say she didn't. She didn't cooperate with the local authority. Well, it's not clear from the judge's comments, what is it that the mother didn't cooperate with? I mean, the point in 441, she didn't mention she'd left the child in the care of the paternal grandmother. Well, of course, the paternal grandmother was able to care for the child. That was the plan of the local authority. No indication that the grandmother thereby brought the child into contact with the father. And so what is it within that that the judge has found? And we say that in itself is of real concern. My learned friend on Miss Merking's counsel on behalf of the local authority says, well, the fact that the judge has said it's a limited finding, and don't worry, because it's not had much impact, if any, in terms of my overall thinking, so you can rely on that. Well, we say that can't be right. The judge recalled the mother to the witness box. She had evidence from the social worker. She clearly thought this was a very significant issue, and she did that in the light of the local authority accepting that there'd been no contact between child and father. So there was something more that the judge was looking for. Now, we say, in fact, the judge didn't find it. But we can't be clear about that because she does say she made limited findings, but we don't know what those findings are. But what we say on behalf of the mother is that this highlights the judge's anxiety. The judge is extremely anxious that this mother will not be able to protect. And she's anxious because of the expert's assessment and the concerns that the local authority have. I do not seek to criticise the judge for being anxious about that. The whole point of the hearing was to decide what risk the child faced and whether the mother could protect. It was entirely right. Where we say the judge goes wrong is that despite everything the mother's done, despite not finding that smoking gun, the judge decides that this mother does not have and has not demonstrated the protective instincts required to keep that child safe. And she does that on the basis of a list of findings in respect of the mother's dishonesty. And if one turns, my lords, to those summary of findings, at E79, the court will see there the breakdown that the IVF process, the parents' relationship. I agree with the expert and the guardian that mother remains in love with the father, wants to be in a relationship with him, and I worry that she will enter back into a more meaningful relationship with him given the opportunity, or if she thought this would remain undetected. Well, just on that point, she's clearly had the opportunity and not taken it. And as to whether she thought it would remain undetected, I'd ask the court to bear in mind that this mother wasn't under 24-hour supervision. This child was left in her care. There were regular visits, but those were occurring on a 4 to 6 weekly basis. There had been plenty of opportunity and plenty of opportunity to meet the father in an undetected way. There's no evidence that either of those things happened.
I take it, because the judgment is silent on this, that there was no evidence that the father himself had sought to inveigle himself into the mother's life or into the child's life, or to overstep the clear boundaries laid by either the Section 38A order or the working agreement.
Yeah, well, there's no evidence that that happened. In fact, the evidence, and it's the last finding, number 7, summary, we have there the finding about the father. And the judge uses this behaviour, the Welsh Tinder allegation, which is the father seemingly reaching out to others, highlighting his ability to be dishonest and manipulate, but no evidence that he sought to undermine the child's placement with the mother, because of course any attempt to breach those orders, to reach out, would have done that. And there's no evidence before the court in that respect. The findings in respect of the mother at 3, the mother has not demonstrated an ability to instinctively protect. Well, there may be many things that people do not do instinctively. There may be many things that people do counter to their own thought processes, their own internal logic. But the fact is, instinctive or not, the mother has protected the child. The court is by now well familiar with instances where parents are worked with, where findings are made that either they or a partner or another carer have caused injuries to a child. Whether or not a parent accepts the findings, we say, is not as important as whether or not they act as if those findings are true. It's the actions that count. And throughout, mother has been criticised for what she said, what she may have said, and that has detracted focus from what she's done.
Can I just ask, the concept of instinctively protecting, is that a concept used much in the family courts?
It's not one that I'm overly familiar with in
Mr.
terms
Goodwin is shaking his head, but it's just not a phrase I'd come across before.
We'd say the danger with instinctive protection, it's if it's counterbalanced with, well, that's where the mother's starting point is, given her own personal history and so on, so she has to work at this. If that's counterbalanced with, and she has, or she's not been able to, then one could see why that might be a helpful assessment. But we say it's unhelpful in this case because what it's done, it's taken the emphasis away from the reality and focused the judge's attention on, well, what this mother is instinctively capable of means that she's not going to be able to protect in the future.
Well, to be fair to the judge, it comes from the psychological report.
Absolutely, and that's why I say that it's distracted the judge.
And one comment that jumped off the page in this context from the family group conference, would you just have a look at, because I wanted to establish a piece of information, a bit of fact from you. But if you look at electronic 330, I think it's probably F 91, 92, 93 probably.
Yes.
There is a social worker present at the family group conference whose initials are YM.
Yes.
Sorry, I'm not on the right
So
page.
sorry, it's I think it's electronic 330. I think
Is
it's
this the core bundle or supplementary?
in the core bundle.
It should be. I think it starts.
Oh, sorry,
Lords,
it's-
at F159.
Unfortunately, pagination is
Yes, unfortunately.
obscured by the
The logo,
logo.
yeah.
I think it's internal page 4, my lord. I think.
The top of the page, it's the family group conference. The top of the page is if M should stay with C, the mother. The question, perhaps, have you got that, Mr. Newman?
No, I think I have, my lord. Yes.
It's the penultimate paragraph in blue in the electronic version, and it opens with the four names of the paternal grandparents had a meeting with YM.
Yes, I have it, my lord.
Could you tell me YM is described as the previous social worker? When did YM and it was? Could you maybe that was Mayor is going to be in a better position than you to tell me this, but do you know when YM was the social worker?
Just
For what period? But the reason I ask that is because when I look a little further in that paragraph, it tells us that that social worker told us that she was doing the mother's parenting assessment. She said she had no problems with the mother looking after M. The mother was a very good mother and a very strong lady who would have no trouble in protecting M. And I wanted to really get the context for that, because that sounds like it's a social worker speaking, and I want to know what the level of experience or knowledge of this mother that social worker had when she was saying that in the summer of 2024, shortly before the hearing.
Well, I'll just turn my back if I may. My lord, subject to clarification, we think that YM is one of the initial social workers.
Yes.
She was involved until the end of 23.
The first 4 or 5 months of M's life. Oh yes, in fact there was a gap, wasn't there?
There
In
was.
6 weeks, presumably then from YM leaving
To the new social
new
worker.
social worker beginning in sometime 6 weeks later.
November 23, I'm being told, is the end of YM's involvement. Then there's the hiatus with no social worker until early 24.
Yes, mid-January 24, I think.
So there's clearly ongoing social work going on with the mother there, and it's rightly recognised in that meeting. And this is the point we've made in the written submissions, is that this mother hasn't been just left to her own devices. There is a level of scrutiny, and one can understand why the local authority felt it appropriate that the visits were taking place every 4 to 6 weeks. It may explain the lack of urgency in allocating a new social worker. There was clearly confidence on the ground, as per those comments, that this mother was not only providing a good enough level of basic care, but she was also safeguarding. And that's what we say is really absent from the judge's balancing of all the factors. My lord is quite right to say that it's the expert that highlights the concerns in respect of mother's psychological profile. And that expert makes it absolutely clear to the judge, and the judge records this in the judgment, where she says that I'm approaching the mother from the psychological angle. It's at paragraph 186 of the judgment. And that's on E28. Paragraph 186, my lord, starts, the expert readily accepted that there were a number of positive factors. And she lists them. And then when it's recorded there that the expert was challenged as to the fact that she hadn't assessed those positive factors, given them sufficient weight, she says she disagrees with that. She considered it was helpful to clarify that her angle is the psychological angle. That's clearly an important piece of the jigsaw for the judge. But on the mother's behalf, what we submit is that the judge was so impressed by this expert and this evidence that she took a piece of the jigsaw and turned it into the whole puzzle. This is only part of the picture. The judge should have balanced against that, not just the fact that the mother was providing basic good enough care. She should have at the very least recognised that the mother had safeguarded the child from the father. And to my lord's point about the father posing a risk in years to come, that the mother, through her actions, didn't use that as an excuse to breach a working agreement or to invite breaches of the orders.
Just on that point, which is the assessment, if you look at the end of paragraph 201 of the judgment and the final sentence summarising the psychologist's evidence, what evidence did the psychologist give for that opinion, which obviously was fatal to the mother's case on the judge's findings?
Well, this is the bottom of page E.
No, it's the top of E31, para 201, final sentence. Dr. Garrett is reported as saying.
Yes. Well, I think that there's clearly no evidence that that would happen because the strictures hadn't been lifted. And in fact, the mother wasn't suggesting that they should be. So we would say it's expert-based speculation. But it assumes that there would be leeway any more than there had been.
And what gives a psychologist the right in a family court to give that opinion evidence?
Well, the right comes from the court's decision, indeed the party's decision, that there needed to be a psychological assessment of the mother. And based on that psychological assessment, this expert identifies not only the psychological profile, but then factors that profile into her assessment of how the mother is likely to deal with risk in the future.
But just repeating my lord's question in slightly different words, what is the expertise of the expert to opine as to the propensity of an individual to comply with arrangements in the future?
Well, my lord, I would say that the only time where an expert can properly do that is if there's factual evidence that it's happened in the past.
But in that case, you don't need the expert because the court can draw the conclusion itself.
In this case, because we don't have that, the court couldn't draw the conclusion based on mother's behaviours. The court turns to the expert and says, well, you tell me about whether this mother can be trusted in the future. And the judge then relies entirely on an expert's assessment from a psychological point of view as to whether or not the mother is going to be trusted or is going to be a risk for this child. Now, it's accepted in authorities.
Well, yes, but can I come back to my question? My question is about expertise, because at least in the abstract, one can contemplate the possibility that there may be an expert in human behaviour who will come to the court and say, I've done a lot of research on human behaviour, which enables me to predict which people will comply with arrangements and which people will not. Now, at the moment, my understanding is that Dr. Garrett, whatever her other eminent qualifications, did not purport to possess such expertise. Am I right?
Well, look, I don't have her CV within the bundle, but from my understanding and knowledge of Dr. Garrett, that's right. She doesn't have that.
Yeah.
Which begs the question as to why is it that she comes to that conclusion despite what the mother has done for 15 months? Because one can imagine, my lord, an expert who's done the research that my lord's alluded to, saying, well, ordinarily, I'd be very concerned. And the propensity and that would tell me, and my research tells me, but given the fact that this mother has managed for 15 months not to take advantage, not to expose or exploit that leeway, my view is not so certain about her. But this expert says, from a psychological point of view, this mother is going to exploit any leeway, deviate from any working agreement. But she doesn't, we say, no matter what she says she's done, she simply hasn't looked at the reality. And that's where we say the judge has placed undue weight on the expert. Because the expert is going beyond identifying what help the mother might need, the support she might need, because she makes those recommendations. She even makes a recommendation about relationship counselling between mother and father. So she makes those recommendations in the light of a psychological assessment. But we say she oversteps the mark with mother. And of course, the judge recognised the danger of experts overstepping the mark, and that's at paragraph 208 on the next page. Because what she says there is, whilst it might be said the expert has raised concerns about the paternal grandparents' ability to protect Lily, it must be right that I pay little regard to those, bearing in mind she's not conducted the in-depth, comprehensive assessment of their ability to protect. That's been the subject of a different risk assessment by others. That is not to say there's no validity in what she has to say about them, but rather, in my judgment, I cannot place the same weight upon her observations of the paternal grandparents that I can upon her comprehensive reasoned analysis of the parents.
So that seems to be identifying an evidential vacuum concerning the paternal grandparents. So where is that evidential vacuum filled?
Well, my lord, in terms of an in-depth comprehensive assessment, the only evidence there is the connected persons assessment of the grandparents, which was not updated after their interventions with the guardian. So she says, the judge, that I've got the evidence of the expert, in essence, in respect to the mother as to propensity, so to the father. This expert, who I rely on in that respect, flags up concerns about the paternal grandparents, but I ignore that because I've got a social work connected persons assessment about the grandparents. So I don't need to worry about that. So whilst there's not a complete vacuum, there certainly isn't the same sort of assessment of the grandparents as being conducted in respect to the mother and indeed the father.
And that has, I'm afraid, triggered a further question about something I've already asked you about. So, of course, this report was before the judge when she decided that she wouldn't hear from the paternal grandparents, i.e., so that she couldn't, so that this evidential vacuum to which my lord has referred couldn't be filled in oral evidence. You may have said this already, forgive me if you have. Who actually made the suggestion or application, perhaps, that the paternal grandparents should give evidence? Was that made on your behalf, or was it made on behalf of the guardian?
The guard.
Guardian.
My lord, yes. And it's right also just to highlight the fact that not only the report, but there were ongoing interchanges between the parties and Dr. Garrett, an addendum report, which is from June,
Yes.
the end of June, and further email responses from Dr. Garrett. And some of those, we reference them in our skeleton argument, certainly that Dr. Garrett's view about the mother and the fact that the expert was clearly unhappy with the challenge being put by the mother to her assessment. And that was something that the judge alighted upon and relied upon to say, well, actually, the mother is expending a lot of time arguing about these issues. And that tells me she's not got insight. And that tells me she isn't going to be protective, and indeed the word used by the judge, proactive, when it comes to protecting. We again say that oversteps the mark, because, as indicated, there are many cases where parents don't accept findings. They might not agree with them, but they can still be worked with to provide good enough care, because whether they like it or not, those findings mean certain things are necessary to protect a child. And so long as they stick to that, the child can be safe. So this mother has stuck to what was necessary, what was asked of her, and she's done it. And she's done it without any evidence that she's ever backtracked or placed that child at risk. The court has, in the judgment, lots of references to the mother's attitude to risk, or she's criticised for not cooperating initially, certainly with the family group conferences. And those are all used as markers for why the mother can't be trusted in the future. But what we say is that those have been given undue weight because they are used to undermine what the mother has done. And on that point, it's we say of relevance, the case of Re-F, which is in the authorities bundle at 236.
Sorry, the page again, 236.
236 is the start of the report. The paragraph, it's paragraph 25 of the judgment of my Lord Justice Peter Jackson at 246. And we say that this is actually what has happened in this case. Paragraph 25, similarly, close attention must be paid to the true significance of lies and lack of insight in the context of assessing welfare. Lies, however deplorable, are significant only to the extent that they affect the welfare of the child, and in particular to the extent that they undermine systems of protection designed to keep the child safe. But again, my lords, what we say in this case is that the dishonesty that the court has identified in respect of the mother, and indeed the father, has not undermined the systems of protection.
And do I understand you're relying particularly on the quotation from Sir James Mumby?
Yes.
Important element to local authorities case, father lacks honesty with professionals, minimises matters of importance, immature lacks insight, may be, but how does this feed through into a conclusion that A is at risk of neglect? Conclusion does not follow naturally from the premise.
Well, yes.
And do I understand that your submission is that is equally true here?
My lord, yes. Because when one puts the factors together, the judge was wrong to come to the conclusion that the child should be removed.
Yeah, and Lord Justice Peter Jackson says this applies equally to the welfare evaluation.
And of course, lies and dishonesty may play a significant role in findings and the threshold. And they're made, and then the court moves on to consider welfare. But just because they are findings in respect of dishonesty does not mean, they automatically mean, the mother can't be trusted in this case to provide for the child's safety and security. And, my lord, that leads me just to the final points I would wish to make on behalf of the mother. That's our submission that what the judge did not do was properly evaluate how placement with the mother could be supported going forward. The child was with mother under an interim care order. The local authority's position, final position at the hearing, was that if the court was not with the local authority in removing the child, then the better way to protect the child would be under a supervision order, because that would provide more scrutiny than a care order. Now, the mother's position was that she would accept any order, do anything to maintain the child in her care. But if the court is going to decide that what has been in place or what could be put in place is not going to be sufficient, then the court has to undertake a proper assessment of what might be available, whether it could work, if it could, why, and if it can't, why. And we don't see that in this case. We don't see the judge going through, well, the reason that an ongoing placement supported by the child protected with won't work is because. And we say, well, there's an obvious reason why the judge hasn't done that, is because the only evidence the judge has is the list of protective measures, which in large part could be replicated beyond the final hearing, have worked.
Although the judge had at an earlier stage of the process, I think possibly at the IRH, I'm not sure, directed the local authority to file what I think was called a shadow care plan, which would be the care plan that would be in place if, contrary to the local authority's primary position, the court reached the view that the child should be placed with the mother. Am I right?
Yes, my lord is right.
We have, I think we have a copy of that shadow care plan in the supplemental bundle. I recall that
E24.
the supplemental bundle. Yes. So we can see there that in some detail, the local authority have set out what the proposals would be under a care plan with the child placed with the mother.
Yes.
So then we look for where the judge deals with the shadow care plan, because that would have given her in one place the mitigating factors, the protective factors. And as I understand it, that you can tell me if I'm wrong, she records the fact of the shadow care plan at paragraph 62. And at 243, she says that they've provided, the local authority provided the shadow care plan. But I didn't see any other specific reference to it.
No, I mean, what she goes on to say in paragraph 243, the social worker does not consider the mother is fully separated from the father, suggested that the mother needs to make a solid decision, suggested to the social worker there's not been consideration of a plan with the child being in mother's care, and she refuted that, setting out that the local authority had considered that as provided the shadow plan as directed.
Yes.
Well, of course, it only provided that shadow plan at the direction of the court,
Yes.
because the original plan had no reference whatsoever to the child remaining with the mother. And rightly, the judge said, well, I need all the options, please.
Yes. But then that, we then need to look, don't we, at what the judge then ultimately says about whether there are any steps, I think it's 492,
it's, I think, my lord, it's E47.
So it's a bit earlier on.
It's paragraph 484. And this is where the judge goes through the list of considerations set out in Re F and Re K.
Yes.
And it's paragraph 4 of that list.
That's it. Thank you.
And what she says there is, what steps could be taken to reduce the likelihood of harm arising or to mitigate the effects? And the judge says, I do not consider that there are any steps that could be taken at this time to mitigate the risks to the child in mother's care. I consider that there is a possibility in the future that a return to her mother's care may become feasible. However, this would have to be subject.
Yeah.
The guardian suggests there should be injunctive measures in place. However, these would require the full cooperation of mother in identifying and then disclosing any risk to the authority. For the reasons I have given, I have no confidence that the mother would be able to spot the signs. Well, so the judge doesn't engage with the various elements of the plan, and then she roundly says, well, I've already told you what I think of mother's ability, and for that reason, nothing's going to work.
I think I'm right in saying that under section 38A of the Children, the exclusion provision, that order can only be made with the consent of the person who is to be protected, namely the mother. Presumably she gave her consent at the outset.
Yeah. She, as I say, in evidence, she made it very clear that she would do whatever was necessary to maintain that place.
Can I ask two legal questions, if that's right? First of all, how do you deal with Miss Mayor's points that, well, this is all fine, you're just picking away at the edges? You know, you're saying this wasn't taken into account, the judge's evaluation of that was wrong, and Fajan Jabani says that's not what we're here to do.
Well, my lord, what we submit is something that goes well beyond the edges. What we say is that the judge fundamentally failed to appreciate how this mother will protect against the risk identified for this child. So it's not that there isn't, or rather, it's not that this is the window dressing in the judgment. These are fundamental points, we say, that when you take them in combination, the acceptance of the expert, the acceptance of the local authority's plan, with all the difficulties attendant with both of those positions, the fact that the judge did not give proper weight to what the mother had been doing, in a sense, it's irrelevant that she doesn't set that against the mother's own difficulties, but we say all the more remarkable because of them, but she doesn't factor that in. And then when she looks to issues of welfare, she's allowed her findings in respect of the mother to overbear her consideration of welfare. She recognises that the child will be disturbed by a move. She goes on to, though, identify that this mother cannot care for this child, despite all the evidence to indicate that she can. The court would be forgiven for thinking, on reading that judgment, that the judge was being invited to place a child in the care of mother in the light of everything. She wasn't. She was being asked to remove a child. And the position the judge was in was not the mother saying, trust me, all will be well, in the absence of evidence to support that. It was the mother saying, I will do whatever is necessary, and you can trust me to do that, given what I've said. So we say it goes well beyond unpicking a turn of phrase or a failure to identify specifically these matters. There's enough, we say, in the failings of this judgment to indicate that it's a fundamental problem in terms of the final decision.
Thank you. And can I then ask you about paragraph 462, subparagraph 4, where the judge said there's a presumption that children's best interests are served by being brought up with their family whenever possible. and then says placement within her family are the only options being considered, there is no presumption in favour of being brought up by a parent over any other relative. Is that really the law of England and Wales?
Well, I think that the approach is almost always the child should be brought up by natural parent. And is there a good reason for the child not to be brought up? We have the threshold, which must be crossed against the parents if the court is then going to embark on welfare decisions about where this child should live. And so to say that there's no presumption in favour would indicate that all individuals come to the court in the same position. It's parents against whom findings are almost always sought. It's against parents who the court then decides, can the child remain in the care of the parent or be returned to the care of the parent? So in terms of the suggestion that, well, children should always be brought up by a parent, that's clearly not right. They should be brought up by a parent unless they are at risk or suffered or at risk of suffering significant harm. The judge is there putting, I think clearly in this case, the grandparents on the same footing as the mother. And we say that would be wrong. What the judge should have done is rule out the mother and then go on to consider the grandparents. Had she done that, she might have paused to consider the difficulties in terms of the grandparents' position. But what she in fact did was decide that the grandparents could provide better care than mother, and therefore the child would be safer with the grandparents. What she needed to decide was that the child would not be safe with the mother. She does that, but we say actually she was wrong to do that. And to have the grandparents in the wings as being better carers, again, took the judge's eye off that particular legal ball.
Thank you.
I wondered whether, because all of the leading counsel are accompanied today by juniors who appeared at the first instance hearing, but at 463, following on my lord's point, the judge records that it's accepted by all parties, by which I think she means by all counsel really, that there is no explicit statutory provision which imposes a presumption in favour of children being placed in parental care. Is that what the discussion was?
That was in the skeleton argument. It was in your skeleton argument in the supplementary bundle at page 135. That there's an explicit statutory provision.
Well, no specific statutory provision. I'm not going to suggest that there is a specific statutory provision, but of course, when one looks at the Children Act, parents are put in a different category when it comes to applications being made. They don't require leave. Grandparents do.
But there must be case law on this.
David,
Yes.
can I give the reference?
Certainly.
My lord, apologies for interrupting. It's a decision of this court in Re N 2024 EWCA Civ 938.
EWCA Civ 938,
Yes, my lord.
and I suppose that's not in the bundle.
No.
No, and it should be, so we'll have to make sure
Don't worry.
it's sent through.
Thank you.
Do you have a paragraph reference as well, Mr. Goodwin, since you're so on top of this?
Okay, to rely on.
Well, it's a decision, it's a judgment of Lord Justice Moylan in relation to whether there is a natural parent presumption, and if your lordships look at paragraph 58 of that judgment onwards, the judgment ends at about paragraph 70, so I hope that isn't
Okay, but that's the relevant section, thank you.
I'm urged to remind my lords that that judgment postdates.
Yeah.
So it's our fault for not highlighting that, and we should have included it in support of that.
Thank you.
My lords, I think that has allowed me to cover the main points. I haven't gone through 1 to 8 specifically. We've grouped in our skeleton argument where there is significant overlap, and I've tried to address those 3 areas together so as to avoid some level of repetition. And are there any other matters I can assist?
There is one question. Obviously, we have to hear from all the other parties. But if, and I stress if, we come to the conclusion that the appeal should be allowed, what do you say the appropriate form of order would be in that event?
My lord, if the court were to allow the appeal, that would involve, one option of course is that the court could replace the care order with a supervision order. But of course that would mean the court not being in a position to consider whether placement with the mother under a care order with attendant support might be a better outcome. And the only way to allow for the lower courts to consider that issue would be to make an interim care order and remit the matter for further consideration. And I think whilst on behalf of the mother she would dearly wish that matters come to an end as soon as possible, I think the reality is the need for there to be a vehicle to consider all the protective measures which the mother says that she would engage with. My lords have already indicated the role for the father in agreeing any working agreement, any injunctive orders. Those are all likely to need the oversight and, of course, argument to be made in front of the lower court. So that would require an interim order of some form to be in place.
So in other words, if we went down that road, that would involve, as it were, reinstating the interim orders and arrangements that had been in place prior to the judge's final order.
Well, yes.
Yes. All right. Well, again, repeat, if we get to that point, I think it will be necessary to consider to what extent and on what basis any further hearing in the family court should take place. But as I say, that can be considered as and when we get to that, if and when we get to that.
Cool.
Thank you.
Grateful. Thank you, my lord.
Yes.
My lord, can I try to assist with some of the questions that have been raised in relation to, and you may already have had the answer to this, but in relation to the paternal grandparents and whether the child had actually visited them or stayed with them. Obviously, we're talking about a child where proceedings commenced very shortly after birth. The child had come out of hospital, the father moved out of the property to the grandparents. That, however, did not mean that grandparents were not familiar figures, which is something that, in fact, Her Honour referred to, because they were part and parcel of the mother's support network once the father had moved out of the mother's family home. So they were, we would say, familiar figures in relation to this child and in relation to the mother and how the child was being cared for and how the child was presenting. So passage of information as well as physical ability to see how the child was doing. Also in relation to the grandparents, and I will obviously hear what is said on behalf of those who represent the child, but my understanding of the situation based on instructions from those who were present was that it was a suggestion rather than a formal application for the paternal grandparents to give evidence, made at an early stage in the process of the hearing, which it's right received either lack of interest or rebuff by the court on the basis that she had material in front of her. But the information that she had went beyond what was said in the connected persons assessment and indeed what was said in the psychologist's reports, because following the family group conference, which my lord has already taken us to, there had been some concern about the comments that the grandparents had made then, which led to that being revisited directly with the grandparents by social workers. And so that was before the end of the proceedings.
Well, indeed it was, but where is it in the judgment?
that it had been revisited by social workers. My
So
lord,
I assume you're talking about the email of the 4th of November.
no, I'm talking about after the family group conference. There is an earlier stage in the
Okay.
process. So it wasn't after the grandparents became aware of the decision that the judge was making. At an earlier stage, she had also had the benefit of there having been work undertaken by way of testing out with the grandparents what their understanding was and what their views were.
Okay,
Can
well, I
I-
think that's an element in the picture we haven't fully grasped. So please, can you as to what transpired in that respect?
Yes, can I try and deal with it this way first of all, because one of the important points that we would wish to make, it having been on behalf of the child that the application was made for the grandparents to give evidence, is the way that it was dealt with by the guardian by the time he came to give his evidence about the grandparents. So if I take you in the judgment, please, and just bear with me one moment while I move something out of the way. Can I take you to, for example, paragraph 394, which is at the top of E60. Where you have the court recording what the guardian was saying in relation to the position of the grandparents. It starts at the top of the page with, he argued against his own earlier proposal for a supervision order. The guardian considered that the grandparents were now more advanced in their understanding of the risks, and that was one factor when he had to consider the realistic placement options before the court. He says, the judge goes on to say, and I'll deal with that in due course. And then if we look further on at E63 to paragraph 417, where we have this, the guardian was asked to compare the two realistic options for Millie, namely placement in the care of the maternal grandparents or remaining with her mother. He accepted the risk is higher in the mother's care and suggested there was enough core evidence to suggest that Millie would be safer in the grandparents' care than in her mother's care, but that he did not consider that she would be unsafe in her mother's care. And then perhaps bringing this little exercise with the grandparents' evidence with the guardian's evidence to a close, 483 at page 73. So Honor then sets out what was the position, obviously prior to their, as I understand it, but I'll be corrected if I'm wrong, prior to them then raising a query. 483, whilst it's not said that the risk of the child being placed in her grandparents' care is risk-free, nobody disputes the robustness within the connected carers assessment. Whilst concerns were originally raised by the local authority about grandparents' ability to protect from risks posed by the father, these have been comprehensively assessed. The local authority has explored with Mr. and Mrs. M how they will keep the child safe and have concluded that they will prioritise her. My understanding is that that is the reference to the meeting that there was between the social workers and the grandparents after there had been concern raised about their comments in the family group conference.
Is that not dealt with at paragraph 251 in the judgment? That particular bit of evidence.
If you bear with me just 1 minute, please, my lord. Yes. Well, I say yes, but it went beyond that, and I had understood that this paragraph at 483 was on the basis of additional information that had come after the visit, after the family group conference, which is not alluded in paragraph 251. May I just turn...
Can I just ask two questions? And I'm not expecting you to answer them individually, and you may well need to take instructions.
Certainly.
But first of all, insofar as there was a meeting between the social worker and the paternal grandparents after the family group conference, presumably that's documented somewhere. Where is the document? Secondly, where is that referenced in the judgment?
Where is that document referenced in the judgment, or the specifics that it was a meeting?
Well, the specifics of the meeting and what transpired.
Yes. My lord, can I come back to the issue of where the document is? My apologies, my lord. My lord, with the assistance of my helpful junior, the social worker involved with that was the connected person social worker, not the social worker who's referred to in the paragraph that we've just been taken to by my lord. The meeting was then, as I understand it, noted, the outcome of that meeting was notified to all of the parties by way of email communication, and that would have been, I'm told, on the 6th of August. That email communication was in the old bundle, but isn't in any of the appeal bundles.
All right.
I'm not going...
Is that email referenced anywhere in the judgment?
I don't believe it is. Hello, can I take...
So what do you say about 483? Because it seems quite a remarkable paragraph, because it seems to be, well, here are people who are completely untried and untested, and this is going to nevertheless give them, the child, less safety and security than the mother who has been tested under considerable fire, it might be said, for 15 months. And what's the basis for that conclusion?
That the grandparents will give her more safety and security, my lord, because although they haven't been tested in the court arena, and they haven't been tested in the sense of having the care of the child, they have been assessed and revisited upon assessments, and the evidence includes...
While continuing to accommodate the father throughout.
Yes. And again, my lord, if we turn that on its head, although the father was being accommodated there, these are grandparents who, it appears, that the guardian also accepted, despite earlier concerns, would be able to offer greater safety to the child. And so the fact that they have been able to develop that position whilst still providing a physical base for the father may in fact give greater credit to their ability in their discussions and their assessments to explain how it is they see him now and how it is they see the need for the child's interest to be put first. And that was, as I understand it, the position of the guardian at the conclusion of the guardian's evidence, because if you see that further down in that paragraph, concerns have been arisen as to whether they have insight into the risks posed by thy son. These have been explored. I remind myself they're experienced parents, solid relationship, concrete support network, who do not have the same emotional reliance on their son as the mother does. Whilst the guardian raised some initial concerns as to the suitability of a placement with the grandparents, in his evidence he accepted that the assessment of them is sound and will be bolstered by appropriate support and training, will be supported by their...
How does all this stack up with the reaction of the paternal grandparents when they were told the decision? Their reaction was one of astonishment and concern that the child was being taken away from the mother.
My lord, I can't go behind what was in the information that the guardian provided, but I am going to again bring it back to the person who had made the application on behalf of the child for the grandparents to give evidence, the person who obviously is the voice of the child within those proceedings. At no subsequent stage was there any further application or even suggestion that in the light of the developing evidence that perhaps now the judge should revisit her decision or her indication that she would not hear from them directly.
Oh, sorry, I thought you'd finished it, sorry.
No, I have, my lord, on that particular point.
May I just ask this, because there seems to be some assertions which don't seem to be evidence, but what we do know is that the grandparents brought up a son who offended. Now, that wasn't their offending at all, but it does seem somewhat surprising that there's not even any investigation about their parenting in circumstances when that's been an outcome. And of course, we know that the outcome occurred when he had become an adult himself, so it may have been entirely different. But is that a not sort of a surprising lack of curiosity on the point?
My lord, I have to accept that the evidence before the court in terms of assessment is the connected person's assessment. It's by a social worker who is in that sphere obviously somebody whose opinion the court is able to give regard to. It is then developed upon in the way that I've explained in terms of these queries being raised and then being investigated.
But something that, sorry to interrupt you, but just can I just be clear that I've understood correctly something you said earlier? Because I hadn't picked this up when reading the judgment, and I'm sure it's just down to my own ignorance and inexperience in this field. But what you told us, as I've understood it, is that the connected persons assessment was carried out by a different social worker, and therefore I'm understanding from that not the social worker who gave evidence.
That's correct.
So the net result is that the judge didn't see the paternal grandparents, and she didn't even see the social worker who had assessed them.
That's correct.
Right.
My lord, however, I come back, I'm afraid, to the same points. You have social work opinion, which is informed by assessment and informed by that social worker's knowledge of the child, of the mother, which in itself is an opinion that says they are better placed to care, despite earlier reservations. You also have the guardian's oral evidence. I don't understand this to be challenged in the way that the judge below formulated it, that even the guardian at the end had come to a conclusion that this child would be safer in the care of the grandparents, albeit not accepting that she was unsafe if left in her parents' care. And so the court is also entitled to rely on the assessment of the children's guardian, when by the end of the proceedings it would appear that the guardian has been satisfied as to their ability to ensure that the child's welfare is put first, and where there is no submission made, and I will be corrected if I'm wrong on this, where there is no submission made, that at that point there is any lacuna in the evidence about the grandparents. My lord, I can understand that it is an entirely different approach to that of hearing from the parents and having a face-to-face assessment of them. It is not unique to this case that the child may be placed with carers that the court does not see. That would normally be in the situation of local authority approved foster carers. But the connected person's assessment shouldn't be regarded as being in some way deficient or the connected persons assessment process shouldn't be regarded in some way deficient, so that in every case where it is a family member who is putting themselves forward to care for the child.
I'm trying to dredge my memory bank, Ms.
Yes.
Mayor, because I think there was an authority many years ago which suggested that judges should be very slow to place children with people with whom they had had no opportunity to form a view, i.e. by giving of oral evidence. I suspect, well, I shall do my researches, you might be able to help, but that private law scenario, maybe public law, but I suspect it's more of a private law
And
scenario.
I think it was also in the scenario of, again, sort of in the kinship, special guardianship, where in fact the court was indicating, it may not be the same case, but another one, where the court was indicating about making an order in favour of somebody who had not been involved in the process at all, and in particular in that.
Yes. But given the concern which you detect we have about this aspect of the
Yes.
case, it might be helpful if you might collectively have a little look through the case law to see whether there is any pronouncement already on this point.
But also, it seems to me that there's a big distinction between a general proposition that you don't need to hear from potential carers when no concerns have been raised in respect of the potential carers. But in the present case, the potential carers are people who brought up the offender, as we've already discussed, and who are presently housing the offender. Seems to me that's a bit different, isn't it?
My lord, yes. I can't pretend that those facts, specific facts to this specific family, are not different.
So the judge is relying on sort of third-hand evidence because she's relying upon an assessment by a social worker who hasn't given evidence of potential carers who haven't given evidence.
And the assessment by the guardian who has given evidence.
Yeah.
But yes, there is a distinction, and I can't pretend that there isn't. But she did have information that, again, in our respectful submission, she was alive to the areas where it was felt there might be problems, that the guardian called for additional information about training and support to be provided, and that was
Can you help me on this? I mean, I'm just trying to think about this in terms of elementary fairness of a process. Think about how this looks from the mother's perspective. She has to come to court, she has to give oral evidence, she's cross-examined about her past behaviour, and yet the paternal grandparents have to suffer none of that. Does that look fair?
if I was in the mother's shoes, or if somebody was taking it from the mother's shoes, no. But it is the process taken as a whole that needs to be fair. I'm not going to justify it beyond the extent that it can be justified. This judge did have information before her. She's entitled to have information that comes from witnesses who do not appear before her. I am not aware that there was ever any suggestion that the connected carers assessor should come to court to be cross-examined by any of the parties. And as I say, despite those concerns being raised, it wasn't just that the judge had effectively closed the door to it, it was that none of the parties before the court felt it appropriate to raise it at a subsequent stage when it might appear that those concerns had resurfaced in some way.
Yeah.
Well, will you give me just one moment? And although obviously this mother was inviting the court to consider that the child should not be removed from her, she was also herself inviting the court, if the child was removed from her, to accept that the grandparents would be appropriate carers, and it had her support. My Lord, can I also then try and just come back to another query that was raised? There is no separate, and it's turning to the position of the psychologist, there is no separate CV within the bundles, but if I could just, for your information purposes, take you in the core bundle to the end almost of the report by the psychologist on the mother, and it's at F147, I think. There are two F numbers, so I apologise if I pick the wrong one, and it's PDF 315, where there is set out in brief but detailed form what's described as the author's credentials, which set out for your information her qualifications, but then perhaps more importantly her experience.
Yes, well, that's helpful, thank you.
And in fact, if you look at the second paragraph under her experience, we can see towards the end of that second paragraph that as well as having experience of assessing and treating, including a range of offenders, including sexual and violent offenders and those at risk of offending, I've undertaken individual, couple and group treatment around the outpatient sex offender group treatment programme at Rayside Clinic when employed in that setting, and continue to treat adults individually on a private basis. And then you also see since 1993 I've undertaken psychological risk assessments in two main areas, and the issue of sexual offenders is included in that. And so in terms of having a body of experience.
Well, help me on this. I can well understand that one of the things that has to be done is for an assessment to be made of the risk of reoffending. That is something that has to be done by criminal courts, by probation, and so on and so forth. Well understand people like this expert will have considerable expertise in that field. But it's not immediately obvious to me how expertise in assessing the risk of reoffending by an offender translates into an assessment, expertise in assessing whether someone who is not an offender will comply with arrangements for keeping a child safe.
Can I, in answering that, take you to another part of this report, just so that you have the picture as to what it was that this particular expert under the Part 25 procedure was being asked to consider, and it's at F141 at page PDF 309. In fact, if you go back to the previous page, because although the letter of instruction isn't in this bundle,
I'm sorry, could you give me the page reference?
F140, which
Yes.
is PDF 308, it's paragraph 14.
Yeah.
So although you don't have the full letter of instruction that was agreed and would be approved by the court, what we can see is that the parties and the court certainly were approaching this on the basis that this was an expert who was well qualified and experienced in dealing with questions such as paragraph 14.2.1 on the top of F141, her ability to protect the daughter from any risk that Mr. Martin may pose. And so with her expertise in understanding, if I could put it in fairly short terms, in understanding the manners in which sex offenders can operate, she brings to this psychological assessment of the mother and assessment of the mother's understanding of risks, that additional expertise as to what it is this mother is likely to have to guard against. I think it, my lord, and I don't mean to be disrespectful, it's not simply a question of whether she would comply with a particular set of arrangements. I'm not entirely sure that that's something that was reported on in detail. There may have been commentary or evidence given by the psychologist as to her psychological approach to whether this mother had the skills to keep her daughter safe from a sex offender who was in a particular sort of relationship with this mother, which I'll come back to. But it was her testing out of the mother's understanding of the natures of the risks that are posed and her willingness to accept those and to take steps to act on those, which were matters that we would say she was well qualified, and the parties must have agreed she was well qualified to comment on when being instructed in the first place.
But it's just the final sentence of paragraph 201. I just wonder if you can help with that.
Sorry, the final sentence of
Paragraph 201 of the judgment.
Of the judgment, bear with me
Which
just
I
one
think
moment.
is E31. Because accepting obvious skill in assessing risks for sex offenders and experience in that, the psychologist has said if there were any leeway or any strictness were removed, her opinion is that the mother would deviate from that. But one, it's not obvious where that comes from in the report. It must have been oral evidence, and we don't have, for obvious reasons, all the transcripts.
Yes.
And two, there appears to be no evidence on which that is based.
My Lord, peppered throughout the judgment, and we hope that we have identified it in smaller form within our skeleton argument, are the types of issues that this mother was being asked throughout, from the beginning of proceedings, to deal with, in terms of then providing information about her reaction, her responses to that. And so it is the issues such as, what had she been told about the offences and at what stage? Because these were parents who were together, I think, from 2016, end of 2016, 2017 onwards. What did she know about the offences? What had the father told her, and what had she then done in order to indicate that she herself had curiosity about the nature of those offences? It was then, what was she saying in terms of his culpability? She does make a comment, and it's picked up upon, about how the offences themselves effectively were horrendous. But she was seen during her evidence, both written and in oral evidence, to offer explanations for the father about he was a very immature, he was lonely, he wanted to make contact with somebody to have some company, without then saying effectively that there was responsibility upon the father for the sexual element of the offences, going as far down in age as a child as 11. It was looking at whether she as a mother took what's been referred to as protective, proactive responses. So knowing about the offences, not then herself demonstrating an immediate reaction in assisting extended family members, so relatives of the father and the nephew that's referred to. The mother knew that there was contact going on there and that both of that child's parents hadn't been given information about it, and she didn't take it upon herself. So it's a combination of various responses, and it's something that then becomes that instinctive parenting that my Lord picked up on earlier. It's that this mother hasn't simply responded in a way outside of the setting of her home and this child to demonstrate that she has the skills and the understanding of all the risks that the father poses.
Yeah, so I take all of those points, but can we compare that with what's said in 208?
Yes.
Where the judge acknowledges that Dr. Garrett has raised concern about paternal grandparents' ability to protect, says, I pay little regard to that because she hasn't assessed them.
Yep.
And she can't place the same weight upon her observations of paternal grandparents, given that she, Dr. Garrett, has never met them. So, is that not a striking disparity?
It is a disparity.
And I mean, more concerning, I mean, and no one doubts the bona fide of the psychologist, and these were her honest views. But if you're sharing your opinions on people you've not even met, it does call into question the reliability of your assessment on the particular person that you have met, because you're not showing the insight. I mean, you're just sharing your honest opinions. When confronted with that, I mean, nowhere, for example, on this psychological assessment, is there an analysis that these are young females that he was offending against, and that the age is there would be a period of time before he was likely to be a threat to the child.
My apologies, I may not have understood the point, my lord.
This is the 5-year point.
Yeah.
Yes, but Her Honour does deal with the evidence that there was from the psychologist about that there was research, albeit the percentages may have been lower, and I'm just going to quote, and I'm sorry I haven't got the paragraph in front of me, about a 25% chance, effectively, of the fact that somebody has abused an older child does not mean they would not be capable and potentially a real possibility of abusing a younger child. The fact that it was a non-family member doesn't again translate to being that a family member is therefore protected, and that is reflected in Her Honour's revisiting of the psychologist's evidence.
Is that paragraph 130?
113, did you say?
130.
130, thank you very much.
That's where she talks, that the judge references the 23%
Yes.
of subjects.
Thank you, my
family,
lord.
non-family.
And although, my lord, there is the reference quite clearly that the psychologist indicated it may not be an immediate risk, but what we're looking at is something potentially in 5 years' time. It went on to...
Well, it might even be longer than that, because look at what's said later on in that paragraph. She said this would be a particular concern as his daughter became older, and once she and her friends reached the age of his
Yes.
victims, 11 plus.
Yes.
So that's 10 years away. So
If-
we take the child away from the mother to protect the child against a risk that eventuates in 10 years' time.
My lord, I think that is a very black and white interpretation of the evidence that was given. Quite clearly, we can look at the age of the victims that we have the convictions for. What I also would draw your attention to is that Dr. Garrett also indicated that because the father had been resistant in her assessment of him as a sex offender, has been resistant in actually assisting in identifying the triggers and reasons for those offences in a meaningful manner, that in fact there must be very great caution about saying those are the only types of offences that he's going to commit at those ages, because it hasn't been possible to understand precisely why he engaged in the appalling behaviour that he did. And also, it's not simply, in our respectful submission, that the psychologist's evidence dealt with the fact of doing a sexually abusive act, but also her concern was that there would be periods of grooming. And so for a child who hasn't yet necessarily reached an age where it would be beyond obvious that the child was at risk, there may be a period where the child or the child's carer are effectively exposed to enabling his way into the family. And that was, again, partly
Well,
then...
to be sure, I mean, nobody is disputing that the child needs to be protected from the father, despite the fact that his offending was external to the family and despite the fact that it was with older children. So the question of protection from the father is a given. The question then is, what is the consequences of that in terms of who should have child or care of the child?
My lord, yes, and this judge, we say, didn't just do a knee-jerk reaction. She didn't just go from, here is a father who poses this accepted risk, although I know the father at various stages raised issues as to precisely what the height of that risk was. But what she considered was what, in her assessment, was necessary to offer protection to the child, and whether this mother had started at all down the route of being able to provide that. Can I just take you, for example, to paragraph 493? I know you looked at earlier paragraphs about what she in fact indicated or how she dealt with the idea of what could be put in place. In paragraph 493, she is looking at what in fact she as the judge assesses as the way in which changes would need to be made in order for the child to be kept safe. And those are set out in quite clear terms, that she must remain separated from the father. It must be a complete and utter separation, not simply physical, which is what the injunctive type relief would assist with, but an entire emotional detachment, which only the mother can bring about. This must be an actual separation that withstands the test of time, and which the mother must be prepared to demonstrate in its finality. And that is something that we say clearly the judge is considering. The additional raft of orders, the keeping away of the perpetrator, would not assist in achieving that, and that the sharing of parental responsibility, which is what comes with the making of a care order if the child was at home with the mother, would not assist in achieving that. The second heading is the mother must be able to demonstrate insight into the father's offending history, into his displayed grooming methods, into his dishonesty, and recognise that his manipulative pervades all his relationships, personal, familial and professional. So again, the raft of orders that might have been considered whilst this child is placed at home with mother would not in fact assist with that. And I'm afraid I do have to come back to the fact that these were proceedings that had actually been quite prolonged proceedings. So I think at the start of the oral evidence, we were already in something like week 52. And this is a mother who, going back to a point I was making earlier, had known since 2016 or 2017 of the fact that this father had been convicted of some, but there was a lack of honesty even at that stage between them. Not all of the details that she knew in terms of the number of victims and the nature of the actual offences and precisely what this father had done. And so what the judge is saying is that in order to have confidence that this mother would be able, when the intense focus of the court proceedings is off, that she would be able to flag up grooming types behaviours if she saw them from the father, to flag up red flags. The orders wouldn't enable the mother to do that in a timescale on the evidence that the judge had.
Is that right though? When you say the evidence the judge had evidence that the Tinder evidence.
Yes.
And the mother was asked about that, and the judge variously in her judgment refers to an epiphany and a Damascus moment in the witness box where the mother appears to accept that the father has deceived her.
Yes.
she's not making any comment about his offending behaviour. She's talking there about his ostensible apparent fidelity or otherwise to her.
Yeah.
But first question, I didn't detect in the judgment that the judge doubted the sincerity of that epiphany. Do you agree or disagree?
I'm going to disagree, although
Yes, would it be helpful for you to tell me where you think
the
she said?
sincerity may not be the precise bit I'm disagreeing with. It was the motivation and reasoning, which was the judge, and I'll take you to the paragraphs in a moment, but if I can just make the point first. The judge was very much of the view that the mother had only had that epiphany because it was in fact the father being unfaithful to her.
Yes.
It was not at all linked to all of the information that she had had previously
Yes.
about the risk to the child.
Yes.
And so the judge doubted that it was a driver that she, the judge, was looking for, which was putting the child's interests first rather than the mother's emotional response to the activities of the father.
I understand that, but what I suppose the mother's reaction does tell the judge is that whereas the judge had up to this point been working on the basis that the mother was entertaining the prospect of reconciliation with the father, that now looked rather more doubtful in light of the Tinder evidence.
I think, again, my lord, I'm sorry if I've
Yes, well,
interrupted.
no, please take me to the paragraphs where you think.
Yes, again, the judge's approach was that she believed that this had come late, that it had not been tested, and in the light of the various, I think she refers them to as not being open and honest approaches the mother had had in the past about saying she was separating from the father when there was in fact this misuse of words potentially.
That was right at the very beginning, wasn't it?
It wasn't just at the beginning.
Right.
It was at the beginning, at the time that she received the risk assessment and said he wouldn't be part of the birthing process at hospital. She had separated. It was the judge went through a whole host of times where in statements or in oral evidence or in discussions with people such as the psychologist, the mother was effectively not giving a clear, we have separated for all time, and that it shifted. And the judge just, I'm afraid, did not feel an ability to trust the mother that this was effectively such a cut-off point. No doubt she would hope that it would be, but she was not entirely convinced that it was something that she could rely on.
I see.
Will you give me just a moment to see whether I can actually find where it is? And it was one of the reasons why I think the judge also gave explanations as to why she felt that perhaps the guardian's assessment, where he had relied a great deal on his interpretation of the mother being honest and her assessment of the mother's honesty and reliability on matters such as the separation.
Yeah, you see, I'm just looking at what she says in the final paragraph of final sentence of paragraph 300.
Yes.
It was not, this is the judge's comment about the mother. She said it was not until as recently as the Tinder allegations that she could see that Dr. Garrett's report on the father was right.
Yes.
And I didn't see, when I go on in the judgment, paragraph 327, for example, I recognise that the mother's own position has changed. And for the first time in the witness box, she has said she will separate from him, irrespective of whether the child is placed in her care. But this is an extremely recent revelation, not, and this is your point, I think, not on the back of a demonstrable willingness to safeguard the child, but faced with the infidelity.
Yes.
The judge isn't doubting the sincerity of the view that the mother has expressed, is she?
Paragraph 326. My lord, the unanimous evidence of all the professionals is that the mother will eventually gravitate towards the father, such as the strength of their relationship. And I consider that if she has not made the decision for herself to separate from him by now, it is highly unlikely that she will be able to do so in the future.
Forgive me, I don't want to split hairs, but of course all the professionals had assessed the mother before the Tinder evidence had come out.
Yes. She also, I'm just trying to find where she revisits it. My apologies, revisits it again. 428, where she's considering the guardian's position. I find it surprising that the guardian so readily accepted the mother's intention to separate, against the background of having been inconsistent and giving misleading information about the status of her relationship with the father, and against a background of a lengthy relationship in which they are extremely emotionally entangled. So again, I think throughout, although it may in fact be that the mother was giving not only a changed position, but a degree of further information that might eventually lead to a separation, Her Honour was not as persuaded that it was inevitably going to stand the test of time. And that must inevitably be the case for her, in fact, to include one of the changes that I've already taken you to in the latter parts of the judgment.
Could I just ask you, again on this theme about what the judge says at 316? Because in 316, the judge says it was only the tender allegation for the mother to say, I finally understand there is to be, and I will finally separate from the father. Sadly, that approach coming so late today cannot provide me any confidence the mother has acquired any genuine insight into the risk, nor she's acquired any genuine intention to engage professionals in an open, honest way.
Yes.
Now, first of all, doesn't seem to doubt the mother's evidence that she is finally separating from the father. So that's the emotional detachment that apparently the judge was looking for. Secondly, as to risks posed by the father, well, one comes back to where is that risk going to come from if there is the separation that the judge was looking for, and then genuine intention to engage with professionals in an open, honest way. What's that got to do with it? There seems to be a complete logical disconnect there.
The part of the engaging with professionals in an open and honest way is being open and honest about the status of their relationship, and that was something that the mother had not been consistent about in the past. If we, it's the passage that you've already been taken to, 319, I have no hesitation in concluding this mother has given entirely inconsistent accounts about her attention to do with the father, and that until the middle of this final hearing she had every intention of resuming her relationship with him. I also found that the mother has only maintained a physical separation from the father and that she remains emotionally connected to him in many ways. I find that she is still in love with him, that the retention of the home address as his primary address, photographs of him around the house, the family plan are all clear indicators that the mother and father were intending to reunite as a family and had not separated. And so it's part of a parcel. It's not an entirely disconnected suggestion that the open and honesty working in professionals is also associated with whether this mother has and will remain separated. And it seems in our respectful submission that going back to the paragraph where the judge set out what it was that she was effectively flagging up would need to be demonstrated to persuade a movement on of this mother in a reliable fashion. At paragraph 439, it needed also to be able to demonstrate insight into the father's offending history, and into his grooming methods, and to engage and choose to engage in the recommendations. This is the following effective headline from her, as set out by their psychologist. She needs to willingly and wholeheartedly participate in therapy, so the therapeutic intervention will help her process her own loss and grief and help her understand the impact of the father's offending on his victims. It's all tied together in the judge's assessment of this mother. Unless she has a proper understanding of the way to respond to the sexual offences, the father's behaviour, his manipulation, his own lack of honesty, and unless she does that from a point of genuine understanding that that is what is in the best interests of her child because of the risks that are posed, the judge is not convinced of her ability to act protectively and to remain separated, even though there has been a movement on for the first time in a very lengthy set of proceedings that this mother is saying she will separate no matter what the decisions.
Can I just ask a matter of factual detail? The offending the father did carry out, I mean, it's set out in paragraph 9 of the judgment, but subpara 4, 2 counts of cause, incite, prostitution, stroke pornography involving a child under 13. It's difficult to relate that to criminal offences that I know about. Do you know what section of the Sexual Offences Act that was contrary to? And do we have details of the police report? It's not, doesn't seem to be in the bundles.
Information in, I think, probation materials that were before the court, and I think, but I'm not sure whether the psychologist went into the statutory provisions. There was information in the psychologist's report. Will you allow me to make some?
Yeah, but also because one of the judge's criticisms of the mother is, well, she doesn't really clear about what the offending was. I mean, I've read the judgment now a number of times. I'm not clear what the offending is. And I just wonder how fair some of that criticism is of a person who, we all know that people who've been convicted of offences will minimise their behaviour.
Yes, and the father obviously did do that. My lord, I wonder if you will allow me
Of course, yeah.
some time, not necessarily right at the moment.
No, and I'm sorry to ask, it's
No.
just I couldn't chase it down in the either supplementary or core bundles anywhere.
I'm just trying to see whether there is a quick link for me to find it.
I mean, one can see enough to see that it's very serious sexual offending.
Yes, and it, I'm just wondering, because I've put some page references to the old bundle, so I'm going to ask my junior if he wouldn't mind checking in the social work evidence template in the old bundle at C12, which is where I think we have information from the offender manager. But that may not be the point where we find that much
Well,
detail.
DC Bailey certainly gave evidence, but that was mainly about the Tinder allegation.
The offender manager gave evidence about her assessment of risk of the father. That
Yeah.
wasn't just...
Yes, but she didn't say what the offences were.
No, not in a way that's recorded easily, my lord.
No,
to
not in the
find.
judgment.
And I'm sure we would have had in the old bundles PNC checks as well. So if you will allow us a little...
There's a summary by the expert at page F18 in the core bundle. And so there's a fairly lengthy paragraph, which, as I understand it, is the expert's summary of her understanding of the offences.
But normally one has a police report or details.
I'm not entirely convinced, my lord, that there was a police report available. So, my lord, I'm looking at the PNC results that were contained within the old bundle K39.
Yeah.
So the first one, sexual activity, female child under 16, offender 18 or over, penetrate anus, vagina, mouth by penis, body part. that Sexual Offences Act 2003, section 9(1)(a).
Yeah.
Same section for the second matter for which he was convicted, sexual activity, female child under 16, offender 18 or over, penetrate anus, vagina, mouth by penis, body part. The third one, again, 9(1)(a).
Sorry, there were 2 counts of that, were there?
1, 2, 3, 4. 4 counts in the same terms. There must be some form of difference because he received 32 months imprisonment effectively on 3 of them and imprisonment for 4 months on the second of them. The following...
Well, there's, if you look at paragraph 9(3) of the judgment, we've got 1 count of a female child under 16. And then 6 is 4 counts of sexual activity.
Yes, those ones that I have just related to you are the 4 counts of sexual activity with a child under 16. The next one is cause or incite a female child under 16 to engage a sexual act. And then that includes the suggestion that that sexual act includes penetration of the anus, vagina, mouth. That's the Sexual Offences Act 2003, section 10(1)(a). There's then cause, incite, prostitution of or pornography involving the child 13 to 17. That's the Sexual Offences Act 2003, section 48(1)(a). Sexual activity with a female child under 16, offender 18 or over, no penetration. Sexual Offences Act 2003, section 9(a). And again, a second one in the same terms. So there were in fact 14 total convictions.
With 3 separate victims.
Yes.
Yeah. Thank you.
I'm just checking, there's a section 8(1), which is cause or incite a girl under 13 to engage in sexual activity. That involves penetration. And then there's a section 11(1)(a), engage in sexual activity in the presence of a child under age of 16. But I think that, although not reading out all 14, I think that covers...
Yeah, that broadly covers 9(1) to 6. So you say it's section 48(1)(a) was the one I couldn't work out?
Yes, I think so.
Thank you very much. Sorry, I mean, and it's probably completely irrelevant because it's just serious offending, but it is, I mean, these are unusual descriptions.
Yes. And it was also the circumstances around some of those were the not obviously involved for the essentials of the criminal offence, but in terms of the manipulation and grooming side of it, was the threat effectively about committing suicide, the threat of self-harming, so that there was an emotional element.
Yeah, no, I saw that, yeah.
My lord. And I'm afraid I've now lost.
Sorry.
No, it's my fault entirely. Are there any other points arising from the matters that we have just been dealing with before I check my notes about other questions that may need to be dealt with? Would you bear with me one moment? We can give you a more detailed explanation from the original social work evidence template. It was in C12 in the original bundle, so if you want that page extracted, we can give you the additional details.
Thank you.
My lords, our skeleton argument was fairly detailed and took you to
Yes, indeed, and thank you for that.
a number of areas where we say that the judge in fact did approach her task correctly. And with these aspects where there has been challenge, we do have to invite the court to give a proper level of respect to the assessment that this judge has had the ability to do in relation to the mother. I accept it's different for the paternal grandparents, that where she has reached these findings about what she assesses as to be the mother's extent of understanding, of ability and willingness to identify red flags if the child were to remain in her care, are very much informed by her ability to have seen the mother.
Yes, the judge had the advantage of seeing the mother give evidence, and we have not had that advantage.
I know, it always sounds very trite, but it is an important...
No, the authorities make it clear this is a very important consideration.
And it's been over a period of time, so it wasn't just during the course of her obviously giving evidence herself. I think at an earlier stage there was a query raised about the family group conference, and I think, my lord, you raised about a previous social worker. That previous social worker had been a person who was involved in assessing or doing the planning for the parenting assessment of the mother in the October of 2023, and if you go to the beginning of the family group conference, it sets out the attendees. She was not an attendee, she was not a social worker who was speaking at that family group conference.
Right.
So what I think my lord had picked up on was mother's explanation as to what this social worker had said, but I'd just like to go back to that page, and I think it was 330 if I remember rightly.
Yes.
Because the situation with the family group conference is that it is a family group conference coordinator who effectively chairs and runs that meeting, that whilst on the attendance sheet effectively there was the children's social worker at the time present.
Yes.
My understanding is that she was there for a limited period and left the family group conference coordinator. So if you go to page PDF 328, again I'm afraid it's in that section where the dark pagination. Prior to the lister also present, family group conference chair, coordinator KP and social worker AI. So it wasn't a social worker who was quoting that information that you had identified a couple of pages on at 330.
Right.
I don't know whether that assists you at all in...
So the contribution comes from the mother, does it?
That's well, I say the mother, that's me being unfair. The way these notes are worded, I think, is to provide information from what was discussed at that meeting.
Actually, I think it's the paternal grandparents.
Yes, it's them saying, had a meeting with
YM
this
told
person.
us she said she had no problem. So that's coming from the paternal grandparents.
It sounds that way, so I apologise for saying the mother. In fact, again, I'll be corrected if I'm wrong, in the parenting assessments that you do have in the bundle, so in the supplemental bundle at page 4 to 7, that's a document produced by YM, which is a parenting assessment plan, and then the parenting assessment itself, so that plan was in the October 23, but the parenting assessment itself, which is in the supplemental bundle at page 8, is completed by a different social worker, not even YM.
Sorry.
No, my apologies. I'm just trying to indicate that it's not entirely clear that the comment is actually a comment
Rightly
made in,
attributed to that particular social worker.
to the social worker who completed the parenting assessment. I can't see that she
Very well.
followed it through.
Right.
Whilst we accept that there was a period of time when a social worker wasn't in place, we certainly think it was no more than 6 weeks. The information that there is about that immediately available is drawn only from a question put in cross-examination of the subsequent social worker. It was cross-examined on the basis of, are you aware that there was a period without allocation, to which the social worker replied, no, she wasn't. And certainly at that time, the parenting assessment social worker, I think I'm going to say NL, but I may have got her initials incorrect, who prepared the second of the parenting assessment documents I just referred to, would also have been visiting. So although she wasn't an allocated social worker for the child, there was still some input. And so we don't believe that it would have been a period as long as 6 weeks where there was no oversight at all as to how the child was doing in the care of her mother. My lords, are there any particular points that haven't already been raised that you think I may be able to assist you on?
The mother, on the proposal that the local authority was putting before the court, the mother would go from being the full-time carer of M to having supported contact at a contact centre with her for 2.5 hours a week. Am I right about that?
Yes, however, my understanding was that there would be a move towards, with assessing the grandparents,
Yeah.
a move towards there being more flexible arrangements over the mother's contact. The restrictions, the very clear restrictions, were going to be over the father's contact.
But even the mother's contact with them away from the contact centre was expressed by the court to be supervised by the paternal grandparents. Is that right?
That's my recollection. I'm just...
Interestingly, I think it's supported in the contact centre but supervised by the paternal grandparents outside the contact centre.
Yes. My lord, will you give me just one moment, because I want to turn up the final version of the care plan just to check that I'm not misleading you.
Well, I think
It's F167 is where I think that starts. The Corbund. And then we also need, I think, as well, to look to make sure that we have the entirety of the arrangements that there were to
I was
be
looking
made.
at the court order, actually.
Yes, because the court order then
which
has
tells
it.
me what I...
D1.
Yeah.
Yeah, that was the final tinkering.
So my question really then, it was apparent from the Guardian's evidence, because the judge refers to this, that the Guardian regarded those proposals as, I think his word was mean. Does the judge deal with the challenge to the proposal for contact?
My lord, I'm not entirely sure. Because
Maybe a question better answered after the short
I
adjournment.
think you'll get more sense from
Yes.
me, my
No,
lords,
quite
after
right.
the short
I know it should
adjournment.
take time. So we'll pause there and we'll resume at 2 o'clock.
Thank you.